What you know, Alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It is still Saturday, September 27th. We are going to read the order denying Donna Adelson's post-trial motion for a new trial. This was filed on September 25th at 11:26 a.m. No new trial for you, Donna, which I'm sure has ruined her weekend. Let's jump right in. This cause came before the court for consideration of the defendant's motion for leave to interview jurors, motion for a new trial, and renewed motion for judgment of acquittal, all filed September 15th, 2025. The court, having reviewed the defendant's motions, the court filed trial record and being duly advised in the premises hereby finds, as far as the motion for leave to interview jurors. Defendant seeks to interview two members of the jury in her case, jurors 5 and 7. In moving to interview jurors, the motion must set forth allegations that are not merely speculative, conclusory, or concern matters that inhere in the verdict itself. They cite Foster versus State. Consequently, juror interviews are not permissible unless the moving party has made sworn allegations that, if true, would require the court to order a new trial because the alleged error was so fundamental and prejudicial as to matters that inhere in the verdict itself, and they cite Foster versus State. Consequently, juror interviews are not permissible unless the moving party has made sworn allegations that, if true, would require the court to order a new trial because the alleged error was so fundamental and prejudicial as to vitiate the entire proceedings. And he cites Johnson versus State. Defendant's allegations do not establish a prima facie case of jury misconduct, but instead encourage the court to engage in procedure disapproved of by the Florida Supreme Court in Smith versus State. The argued reason for interviewing juror number 5 is that he revealed he considered how the defendant reacted to the evidence and testimony during the trial. However, defendant also notes that juror number 5 expressly stated he did not consider her reactions during deliberations. Defendant's motion concedes that juror number 5 said he did not consider defendant's reactions when deliberating. This challenge primarily concerns that juror number 5 observed defendant's reactions during her trial. By operation of fundamental, procedural, and statutory rights, the jurors are present in the same courtroom as the defendant. It is not impermissible for jurors to visually observe the defendant over the course of a trial. The Florida Supreme Court in Phillips versus State found the fact that 3 jurors briefly viewed a defendant in his jail uniform was insufficient to warrant a new trial. The facts alleged here fall short of the argued prejudice found as insufficient in Phillips. Accordingly, defendant may not have leave to interview juror number 5. The argued reason for interviewing juror number 7 is that she posted on TikTok that she was selected as a juror on August 26, 2025. Defendant provided a video recording of this post, and the court was also able to locate the post on the juror's TikTok account, where it remains as an active post as of the filing of this order. It displays the following text over video of juror number 7, quote, "When I told God I needed a break and he makes it so I'm selected to serve on a jury for 2-week trial, won't he do it?" Along with a caption that reads, "No work, no kids for most of the day. You know what? Heaven, yeah." They have the exhibit attached at the end of this file. It says, juror number 7, TikTok, August 26, 2025, and there is a link to that in the filing. The jury was instructed not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. The court concludes juror number 7's TikTok post does not constitute communication about the case. Rather, it was a comment about her jury service and its length. It does not reveal the parties, the attorneys, the alleged crime, whether it was a civil or criminal case, or even the location of the trial. In other words, it was not about the case. As such, it is not juror misconduct. The TikTok post was not so fundamental and prejudicial as to vitiate the entire proceedings, and again, they cite Johnson. Furthermore, every prospective juror was informed if you are picked for the jury, you may tell people that you have been selected for the jury, and how long the case may take. However, you must not give anyone any information about the case itself or the people that are involved in this case. The defendant did not object to the jurors being able to disclose that limited information. And juror number 7's TikTok post comports with this exception to the communication prohibition. Defendant cannot now use juror 7's compliance with this directive as grounds to interview her. Accordingly, the defendant may not have leave to interview juror number 7. The motion for leave to interview jurors is denied as to both jurors 5 and 7. The next section, motion for a new trial and renewed motion for judgment of acquittal. Underneath it says, contrary to the law are the weight of the evidence and judgment of acquittal. The court does not find the jury's verdict is contrary to the law or the weight of the evidence. When considering a rule, a new trial motion based on the weight of the evidence, the trial court must exercise its discretion to determine whether a greater amount of credible evidence supports an acquittal. The court must weigh the evidence and determine credibility just as a juror would. They cite State versus Bowler. The court concludes the greater amount of credible evidence supports the convictions. The court relies upon its previous rulings, all direct and circumstantial evidence admitted, the evidence demonstrating defendant's consciousness of guilt, and its own credibility determination of the witnesses. Stated succulently, there is evidence in the record demonstrating overt actions by the defendant in furtherance of the murder for hire scheme. See Williams versus State, which says, at minimum, there must be proof of some overt act or some words uttered in furtherance of the scheme that led to the murder. The members of a conspiracy may have more than one objective. The trial evidence demonstrates defendant's objection for the crimes as being completed and separate and distinct from her son, the middle woman, and the triggermen. However, their combined acts resulted in the crimes committed and the death of the victim. Because the objective of certain co-conspirators here was obtaining money through criminal acts, the death of the victim did not terminate the conspiracy until the co-conspirators received their payment. And they cite U.S. versus Hickey. The trial evidence established defendant's connection to those payments. Thus, based on the unique facts of this murder for hire, defendant's case is distinguishable from Williams. The court also denies the renewed motion for judgment of acquittal, relying on its denial of defendant's initial motion for judgment of acquittal. All direct and circumstantial evidence admitted and evidence demonstrating defendant's consciousness of guilt. The next part, decision of any matter of law which arose during the trial. The court does not find error in refusing to admit the complete 2014 and 2023 planners. The state introduced particular entries from the two calendars. Defendant asked to introduce the complete calendars during its case in chief. As an initial matter, the request was untimely under Florida statutes. Although the plain language of the statute requires the adverse party to introduce the other part of the statement at the time the first party introduces the statement, Florida courts have generally allowed the adverse party to delay introducing the other part of the statement until cross-examination. They cite Schreiber versus State. Defendant's request was too late because it came after cross-examination of the relevant witness. Even if the request was timely, it was improper because the purpose of the rule of completeness is to avoid the potential for creating misleading impressions by taking statements out of context. And they cite, gonna butcher this name probably, Lazellery versus State. By its very nature, a calendar/day planner is divided into a series of pages corresponding with the days in a year. Thus, the court concludes the entries the state admitted into evidence were not out of context. They were not one part of a whole. They were specific dates in the calendars referencing specific events, and those relevant entries were admitted in their entirety. Interpreting the rule of completeness to allow for every other entry in the calendars would require the contemporaneous admission of any written or recorded statement that might cast light on an admitted statement. Using the language of Florida statute, fairness does not require turning a trial into a voyage on a sea of hearsay, citing Carter versus State. Accordingly, the defendant's invocation of the rule of completeness was properly denied. Moreover, the court permitted defendant to use the entire set of calendar entries as a demonstrative exhibit during her closing argument, and defendant argued the state did not want the jury to see them. In addition, the 2023 calendar entries defendant sought to admit would not rebut arguments that she was fleeing to avoid prosecution when compared to the vast amount of contrary evidence that existed beyond the planner, such as inter alia, defendant's text messages, WhatsApp messages, Google searches for non-extradition countries, recorded conversations, emergency fast-track visa, and a one-way ticket to Vietnam. The next part, for other cause. The court does not find the arguments presented in this claim warrant a new trial. Specifically addressing defendant's decision not to testify, the court relies on the trial record. After defendant had closed her case but prior to the commencement of closing arguments, the parties were asked to approach at sidebar. There are a lot of attachments listed here, and attached to this document are trial transcripts. The court explained it had performed additional research and wanted to confirm that defendant did not want to testify. The court added, "The reason why I'm bringing this issue to the party's attention is only because I believe the appellate cases of this state make clear, prior to instructions and closing, the exercise of the fundamental right leans towards allowing the defendant to reopen her case if she wanted to testify." Upon the court's inquiry, counsel responded, "We talked to her for a somewhat lengthy period of time last night over the phone while we were preparing. She was informed, Ms. Fulford and my paralegal, that she felt secure in her decision." Defendant was then placed under oath and asked if she was absolutely firm about this decision not to testify. Defendant twice responded, "Yes, I am," but asked for a few minutes to talk to counsel. The court then granted an additional 30 minutes to further discuss her decision. After that time had elapsed, defendant once again stated, "I've made a decision. I'm not going to testify." When asked if she was firm on this decision, defendant answered, "I am." The court concluded, "I will make no further inquiry unless the state or the defense seeks for the court to do so at this point," and neither party did. Accordingly, defendant was provided sufficient time to, and did, make a knowing, voluntary, and intelligent decision not to testify. In denying defendant's other allegation, the court relies on the complete trial transcript of the proceedings. It is therefore ordered and adjudged that the defendant's motion for leave to interview jurors, motion for new trial, and renewed motion for judgment of acquittal are denied. So there you have it. This is 10 pages out of 57. Most of those are transcripts from the trial. Donna Adelson's next case management hearing is on October 14th. I will live stream that on the channel, and sentencing will occur at a later date after a pre-sentence investigation is completed. So that is it for now. Hope you guys have a good rest of your weekend because I'm taking tomorrow off, but we will see you on Monday. Have a good one.